Hello, and welcome to the Canadian Story, where we discuss what Canada is, what Canada could be, and what Canada should be.
Hello, everyone. Welcome back to the Canadian Story. Today, we are very lucky to be joined by Mr. Bruce Pardy. Bruce, welcome to the show.
Thank you, Zach. Thanks for having me.
We appreciate you being here. So, Bruce is here because he knows way more about law than I do. So we're going to do some learning from Bruce today. Bruce, why don't you go ahead and just detail your background for us and the listeners so that we know who you are and what you do.
Sure. Okay. So I've been a law professor for longer than I care to admit. I've been at Queen's for a couple of decades. I'm now also the executive director of a think tank called Rights Probe, which is a law and liberty think tank, a branch of the Energy Probe Research Foundation. And both at Energy Probe and Rights Probe, we are a little different than many think tanks in the sense that and we're not the only ones by any means, but we are among the few Canadian think tanks that have a liberty, free market oriented perspective on things. And those voices are very few and far between in this country, but they are, I think, gathering steam, especially in this COVID period. And so there's a lot of important work to do, and we're pitching in to do it.
Okay, why don't we start here? Because I hear the term think tank thrown around a lot by a lot of people in academia and you know who do what you do. Can we clearly define what exactly is a think tank and how does that work? And what is the goal of the work that you do there?
Right. So one of the advantages of a think tank is that you are independent from public institutions. Now, the main one, of course, is universities. Universities have served a very important purpose over time. But universities are also beholden to certain interests, both inside and outside. They're funded by governments and by research councils and private entities for that matter as well. They have very large constituencies inside the institution, faculty, students, administration, and there's all kinds of puppet strings tied to governments and so on. So the function of providing a space for free and open inquiry at the universities is eroding. And the acceptable range of discussion at universities is narrowing. And so, in a way, the think tanks, especially from a certain perspective, are almost stepping into the breach. And think tanks are some of them are charities, as ours is, and privately funded in that sense by donation. And so that gives us and others a freedom that maybe not even really available now at universities because it's become such a loaded ideological place. So that's the space I think that we're in.
So would it be fair to kind of summarize what you said? The purpose of a think tank is to be able to think outside of the constraints of a place like a university where it seems more and more your speech is limited, your ability to discuss ideas is limited. The think tank's purpose is to be able to discuss the things that are off the list at the universities.
Oh, off topic. That's right. It's a place where you do not have pressure to conform, except as it is, as you impose it upon yourself, which hopefully won't happen. But the pressure to conform to a certain view in universities is growing, and so that pressure is not present, at least in the same form, for a think tank.
Right. So, what conversations is the think tank currently conducting? What are the pieces that you guys are discussing that you wouldn't necessarily be allowed to discuss on campus?
Right. Well, so the campuses in this country have been a good example of how should we put it? Extreme COVIDianism. Universities have been amongst the most extreme of COVID panicked institutions. Not the only ones, to be sure, but among the most extreme. And so they have been sort of the first and last institutions to impose mandates and have masking and so on down the line. And it's been a strange time in this country, both at the universities, but of course, much more broadly as well. And so part of our role is to try to provide some clear thinking to what the heck happened over these past 2.5 years. But even before that, I mean, one of my arguments has always been that this COVID thing seemed to be a very sudden thing, came upon us like that, and the country changed overnight. And there's some truth to that. But it was a long time in the making, we have argued. And that has been partly the fault of the law and the courts, but also the growth of the administrative state and all kinds of cultural factors that have grown over time, so that when COVID hit, it was sort of a perfect storm. And these various dynamics came together, and suddenly we launched ourselves into a new kind of social environment where suddenly the population seemed to accept without question that the role of the government was to keep us all safe and to tell us what to do to achieve that. And we'd never been there before. And that threshold has now been crossed. And it was crossed so easily. And people embraced it and wanted more, wanted the government to be harder, and to do it harder and longer, and not to let up, and to punish those people who didn't go along. And it was like, holy mackerel, what kind of country do we have? Where's the country that I know? And it seemed all very fast, but I'm afraid it's been in development for a long time.
That's very interesting. What sorts of things did you observe pre-pandemic that you would now look at as some of the groundwork that was laid to allow some of the things that happened during the pandemic to happen more easily? What did you observe ahead of time that you were concerned about?
Right. I would categorize them and put them into two, and the two things are not separate. But the two things that have happened over time is the expansion, the growth of this managerial state, the administrative state. And the other thing is the way the law has developed over the past few decades. So the state apparatus in the country, and it's not the only country. This is a common pattern in the Western world. But the state apparatus in this country has grown so that it essentially dominates social life. Now, I mean, you can just think of our various levels of government, federal, provincial, municipal, and all of the various organs that are really outgrowths of that state being. All of the departments and agencies and officials and commissions and tribunals and offices all across the board. And all of these parts of the state regulate and direct and plan almost every aspect of life now. It's very difficult to think of some aspect of your life that is not impacted in some way by some organ of the state. And it's become normal for us. People are used to it, but that's not always the way it used to be. And it's not one of the, if I can put it this way, not one of the founding ideas of the civilization that we think we live in. It's happened over time. And at the same time this has happened, it's sort of an irresistible growth in the influence and the size and the determination of the government, and not just the government, all these state apparatuses. And by the way, if I can mention this, people may be familiar with the way that the state is thought of in three branches. You know, there's a legislature, which we elect. There's the executive branch, which is nearly all the rest, and the third one is the courts. But all these three branches are part of this thing I'm calling the state. And then while you have the growth of this monster, at the same time you have the evolution, the development of the law, which is done both by legislatures in passing statutes and by the courts in interpreting statutes and constitutions. And over time, what has happened is that the courts have embraced the idea of the expansive administrative state, and they have laid down the path to make sure that this state apparatus has the ability to do as it thinks best and to do as it thinks appropriate. And that together, in other words, these three branches of government, they have their differences, of course. They have fights about various things, but basically, these three branches of government have been on the same page about the direction that we need to go in, and that is towards a managed society where people who have expertise have the authority, both legal and moral, to direct us in how we choose to live our lives. And that basic idea was the idea at the bottom of the COVID response. Here we have a problem. We have a new virus. It's a threat to certain people. Here are all the experts, and they're going to come in, and they're not going to just recommend. They are going to require us all to act in accordance with their best guess. And people said, sure. I mean, of course, tell me what to do, they said.
Mm-hmm.
And that is the idea that for me is a new threshold, and it's going to be difficult to go back on, because people are now used to the idea that people with expertise have the authority to tell us what to do. And frankly, if you look back far enough, that's an alien idea. The original, well, not original. I mean, there's no original. Everything is evolutionary. But we have a competing idea that used to be strong and healthy, which was people decide things for themselves. And that idea was thrown out the window with COVID.
Right. So it was tossed right out the window with COVID. But your argument is that it was being inched toward that ideal many, many years before COVID, correct?
Yes. So nothing is ever pure. You can't look to any particular moment in history where everything was, all one way or the other. There's always been a tension in our history between individual autonomy and others, collective ideas. So there's no pure moment to go back to. I always try to discourage people to try to go back to stuff. You've got to move forward. But yes, as a matter of historical evolution, we can put it this way: individual autonomy is perhaps the crowning achievement of Western legal systems. We at least established the idea, contrary to the idea that existed, through most of human history in most cultures, most civilizations along the way. The Western system at least managed to establish a vital idea that people should be primarily able to control their own lives and be responsible for them, and should not primarily be told what to do. Sure, we had laws and regulations, of course, but primarily your life is your own. And that is the idea that is eroding.
Well, there's one word in that is the problem, and it's primarily, right? Where does that line lie? That is the question that we are, I guess, all dealing with right now. I would anticipate your argument would be we did not reach that threshold in the COVID crisis, and I would agree with you. But do you believe that there is a line somewhere where it is the right decision for the state to step in and say, we need to take over here, this is what we're going to do? Does that line exist, or should it not exist?
Right. So it's a very good question. And in a sense, you could say that it is the question. It's the legal question, the philosophical question. So one way to imagine the line. So let's step back just one step. So if we say, right, there's going to be no laws at all, like no restraints on liberty whatsoever. You can go and do whatever you want at any time. The problem with that is that means that everybody has the ability to go and impose upon each other. Right? You can go and beat up your neighbor because there are no laws. Right? So in a way, you can describe that as extreme liberty, but also not free, because your neighbor's not free from violence.
Mm-hmm.
So the line that people like me draw, and I would consider myself a classical liberal. The line that we draw is between peaceful coexistence and violence. In other words, you can do anything you want as long as it's not violent. As long as you're not coercing other people, you're not imposing your will on other people, then you can do as you like. You can speak your mind. You can buy and sell property. You can make contracts with whoever you like, but you cannot be violent. That is not the line. I mean, that line exists, but it's not where the state stops. Now, the state interferes in all kinds of ways that are not limited to prohibiting your violence. And I'm sure that
expand on that. What ways are you seeing the state step past that line?
Well, okay, so just to give you some topical examples, notorious topical examples that are coming to the fore right now, the federal government, for example, has been talking about regulating internet speech.
That's Bill C11, correct? That's C11?
C11, yeah. That's correct. C11. The idea that your speech should be managed is extraordinary. Now, it's not to say that there is no limitation on speech. We do have limitations on speech. But one of those limitations illustrates the idea that I was describing, which is you can say what you want, except you can't threaten violence. Right? So if I'm on the proverbial soapbox in the park and I'm saying whatever I think about whatever I think, then that should be fine because I'm just speaking. But as soon as I change what I'm speaking and say instead, okay, all you people, get your pitchforks and your torches. We're going to go down the street and we're going to get that guy. Okay. Now that's not just speech. Now it's violence. Now you're threatening violence. You're planning you're counseling a crime. And so for me, that's the line between just pure speech and something else. But the latest proposals to govern speech are not proposals that are drawn according to that line. No. They want to say that, for example, you're not allowed to discriminate in your speech. And in fact, we have that already in some provincial human rights codes. In British Columbia, for example, there's a provision that says in your public speech, you are not permitted to discriminate against, for various reasons. Okay. That's extraordinary.
Well, it's also vague. How do you define discrimination? Where is that line?
I'm not sure if you want to go down this rabbit hole, but let's just talk about discrimination very quickly. So people have this idea that discrimination is unlawful. Discrimination generally is unlawful, which is nonsense, because people discriminate all the time. I mean, you have a group of friends. You chose those friends by discriminating between them and the other people that you might have chosen to become friends with. Right. To discriminate simply means to discriminate in its normal English language version of the word simply means to distinguish between and treat differently. And we all do that all the time. And laws do that too. The purpose of laws is to discriminate between one thing and the other, to draw a line. It's very difficult to think of laws, and maybe they're out there, but to think of laws that do not discriminate between two things. Okay, so the only kind of discrimination that is unlawful are the specific kinds of telling apart and treating differently that are listed in human rights codes, for example, and they list certain characteristics that you're not allowed to discriminate upon. So, for example, if you are, let's say you run a restaurant, and you think, okay, I'm gonna post a job ad for servers in my restaurant, and they're going to say, please, only very tall, beautiful people apply. I only want tall, beautiful people being servers in my restaurant. Okay, that's discrimination. You're discriminating between short people and tall people, but it's not unlawful, because if you look at the Human Rights Code, it does not say you're prohibited from discriminating on the basis of height. So it's fine. And so on and so forth. So statutes prohibit what they say they prohibit, and really nothing more, but either explicitly or by implication. Mm-hmm. So where were we going with this?
Let me think here. Discrimination was back to.
Oh, well, let's try this. Let's lead to this. So people make the argument during COVID, and quite rightly, that they are being discriminated against if they don't get a vaccine, for example.
That seems to check out in my brain.
And they're right. They are. They're because, the regulations are drawing lines between two groups of people and treating one group differently than the other group. The problem is that doesn't necessarily mean it's unlawful, because you have to go to the code and say, right, on what ground are we not prohibited? Are we prohibited from discriminating against people? And
right.
Vaccination status or medical status, it says medical disability, but if you choose not to take a vaccine, does that constitute a disability? Probably not.
I see the quagmire.
Right? So it is discrimination, but it's not necessarily unlawful discrimination.
Right. So what do you do about that? Because I certainly know a lot of people who would understand that argument, but still feel the way they were treated was unjust.
Oh, yes. Oh, and I agree with them. Absolutely. It's just that it's not quite so easy to leap to the conclusion that therefore it was illegal.
Mm-hmm.
I mean, there are some arguments to make, but they're not quite as simple and straightforward as the one I just described.
Right.
So what we have here, we have both a legal problem and we have a cultural problem. And those two things often go together. So there's an old saying that goes, law is downstream from politics, and politics is downstream from culture. And if you want to fix the law, I mean, you can try to fix it directly, but the implication is that you sort of have to fix the politics first in order to achieve statutory change. And in order to fix the politics, you have to fix the culture. And this problem is as much a cultural problem as it is a legal one. So you have this country. Canada, with a reputation for being, people have a reputation for being such reasonable people, modest, resourceful, self-effacing, self-reliant, tolerant, generous. And COVID hits, and what do you get? You get spite, you get fear, you get dependence, you get viciousness directed against the group that won't go along, that won't conform to a view. Now, that's a cultural thing. It means that unfortunately, it means that picture, that stereotype that I described first, turns out maybe not to be true. Because untested virtue is really no virtue at all. You don't really know what you're made of until the moment when you're tested. And when we were tested, the population became fearful, spiteful, dependent, reactionary, and vicious. And not everybody by any means, but on the whole, that the ethos of the place was to many people unrecognizable.
Yeah, that's a very astute point. And you're right. That's not a law problem. That is a culture problem.
Right.
And I recognize that your expertise is in the area of law, but do you have any comment on what might have created that cultural shift? Like, why did that happen?
Sure. Yeah. Well, this is a very intricate story too. And when you're talking about the way cultures evolve, I mean, there are so many threads and so many different causes and effects and dynamics over a period of time. It's very difficult to pull them all apart. But one of my favorite theories is the influence of a set of academic doctrines, and the main one is called critical theory. And critical theory began its life as an academic doctrine, started between the two world wars. A group of scholars in Germany got together to try and figure out why Marxism wasn't catching on in the West.
So critical theory dates back to World War II.
Before World War II, even.
Wow.
Yeah.
That's crazy.
Yeah. And it's a long story, but to make the long story very short, you have a group of, I'm not sure they would have called themselves Marxists. I mean, some people call them neo-Marxists, and they weren't pure Marxists. So they took, of course, all about Marx and communism and so on. But Marx is essentially an anti-Western thinker. His main thesis was the end of capitalism, and that's one thing that these scholars had in common with Marx. They dropped Marx's emphasis on economic oppression, and instead substituted other things and brought a way of analysis, an analysis that was not just economic, but more holistic in terms of sociology and culture and epistemology and so on. But the bottom line was it was an anti-Western set of premises that evolved over time. And that school of thought, moved from Germany to other places, especially to the US, and over time infiltrated the thinking in various university disciplines, sociology, linguistics, and so on, and then through the professional schools, and basically has conquered the whole place. And so much of our academic thinking now is dominated by a presumption of the evil of Western civilization. And that thinking has infiltrated into the population because, of course, people go to university, they graduate, they get jobs, and they become the generation that runs the show. And Canadians today, many of them are taught from the very beginning in public school through their university days, if they go to university. But in various guises, in the media now, if you read the CBC, this set of ideas is dominant in the coverage that CBC gives about nearly everything now. But the bottom line is the Canadians are told that their civilization is essentially evil. It is oppressive, it's racist, it's misogynist, and it deserves to be either transformed or taken down. And it's being transformed. And it is characterized, this set of ideas is characterized by a collectivist thinking. And collectivist thinking is what you had during COVID.
Mm-hmm.
And I can go on for at length about this story, but those are that's the sort of the basics of this part of the theory. And I'm not saying this is the only cause, not by any means.
Yeah, of course, this story is much more complex.
It's one of those threads that lead to the totality. Yeah.
Right. So this is a concept that we've kind of tossed around on the podcast before. I'm sure it's not the whole solution, but would you agree that perhaps part of the solution for fighting this cultural shift that we're seeing is to focus on redefining how we're going about education? Because that kind of seems to be one of the places it starts, and it's certainly pervasive in the university circles. And I know that you teach law. What have you observed on campus, let's say over the last 10 years, about the students that come through and how they think? What do they exit the university system thinking and feeling?
Well, of course, and I should say this and emphasize it, that everybody is different, right? So some people are not of this mind at all, which is great, but their numbers, my perception is, it's very hard to know for sure, but my perception is that their numbers are few. For the most part, my guess would be that most people accept the premises that I was referring to, and sometimes they accept them without understanding where they come from. I mean, some university graduates will be very familiar with critical theory by name, but maybe not all, and they won't know. So For example, those people who will believe in and promote the ideals of social justice are singing from this book. That's what social justice means. That's partly where it comes from. The idea that society is oppressive, and there is a oppression pyramid or a power pyramid that certain identity groups occupy at the top and certain identity groups are at the bottom. And the purpose of social justice is to flip the pyramid. And to do that, you need to use the law in part as an instrument to achieve this social justice set of objectives.
Okay? Yeah, but if the purpose of social justice is to flip the pyramid, then it isn't even fighting to accomplish what it argues it is trying to accomplish, because by flipping the pyramid, all you're doing is you're putting some other thing at the bottom of the pyramid, right? It's a bad argument in the first place, is it not?
Oh, well, I agree with you entirely. But that would not be accepted. There's
a lot of people who don't consider me very acceptable.
Right. Well, so part of the problem with critical, so people hear this label critical theory, and they may think of critical thinking. Okay, those two things are not the same thing. Critical thinking and critical theory are two entirely different ideas, and critical theory has come to a place where critical thinking is essentially not allowed. You're not allowed to challenge the premises of the theory. The theory is a set of premises or an agenda, if you like. And if you come along and make the argument you just did, which is, well, that doesn't make any sense because your stated objectives are not being accomplished by the means by which you're applying. Well, I mean, that's going to be very unpopular. I've made similar arguments. I've made this argument. You've probably heard of intersectionality. Yes, intersectionality is the idea, a social justice, critical theory idea that people are made up of their identity points, if you like, the various characteristics that define who you are. Your race, your gender, your religion, your background, and people who have certain combinations that all your features sort of combine to create and they intersect to create the victim that some people are. So if you are a certain race and a certain gender and a certain religion, then you are among the victim class. Okay? But the problem with intersectionality is if you take the logic of it to its logical conclusion, then it short circuits the whole enterprise, right? Because everybody number of characteristics. You start with race and gender and religion, but you got to keep going because people are made up of all kinds of features. Your background, your wealth, your parents, the country of origin, your height, your genes, and so on and so on and so on, all the way down a very long list. And but by the time you get to the end of the list, you understand that the only person who belongs to your identity group is you.
Yeah. Okay. Right? So if intersectionality does not define a person, what does?
Oh, well, why do we need to define a person? See, this inclination is part of this school of thought that everybody needs an identity. And the competing school of thought is we don't care who you are. Everybody's subject to the same laws and rules, and we could care less what color you are, what sex you are, religion you are. Just carry on. You're a person like I'm a person. We're just people. Doesn't matter the differences. Just come and live and live your life.
Right. That makes sense to me. The only pushback I would have on that is I feel like if you were to draw on one thing to summarize an individual, I would choose character. Because character doesn't really draw. It doesn't draw on race. It doesn't draw on sex. It doesn't draw on religion. It doesn't draw on belief. It doesn't draw on anything other than how that individual behaves toward the world around them. And I think that would be at the very least, if we have to compromise somewhere, a good place to start.
Well, you see, so, in the kind of free society that I would like to live in, people are allowed to make their own choices about other people, whether or not I approve of them or not. I mean, if you want to, it makes perfect sense to me that you would make your choices in dealing with other people based upon their character. That's reminiscent of Martin Luther King Jr. Yes.
Mm.
The quality of their character rather than the color of their skin, right? That makes perfect sense to me. But there are going to be people in society that will want to do that and will carry prejudice with them. And if they want to make their choices on the basis of race or sex or religion, I mean, if it's a free country, then they're allowed to do that, even if other people don't approve. And so the idea of having these broad discrimination laws that prevent individual free people from making their own good or bad choices is objectionable to me.
Mm-hmm. Let me throw this at you. Here's something that I think about often that bugs me. And since we're on the topic of discrimination, it kind of plays in. So you hear all the time about, we'll call it, I guess, the corporate world,
Yep.
setting aside a certain amount of opportunities, jobs, etc., for minority individuals who belong to a minority group.
Yeah.
That is discrimination, is
Yes.
it not? So, do you have any idea?
Yes.
Do you have any idea why people can't seem to grasp that? Because if you select, even if it is a minority, if you select someone, let's say based on the color of their skin, over someone else of a different color of skin who may or may not be less or more qualified for the job, if the selection process is determined by the color of the skin, I'm going to use the word, that's racist.
Yeah.
Is it not?
Yes. Yes, it is. But you have asked a question that lies at the very core of the difference between these two sort of sets of ideas we're talking about. I'm going to use some labels now, just to sort of make clear what we're comparing. Okay, so the progressive, woke, illiberal, critical theory, social justice school of thought, and the classical liberal, libertarian, Western, merit-based school of thought. And you can apply other labels as well, but basically those are the two sets of ideas we're comparing. Okay? And here are the versions of things in those two schools of thought. We are from the critical theory of social justice, progressive woke side of things. They promote an idea called anti-racism. And on the other side of the ledger, the classical liberals, they believe in an idea called non-racism. Now, those two things sound the same.
Yeah, but they're not.
But they're not. They are opposites. They're opposites.
Yeah.
Okay. The non-racism means I don't care what race you are. And the anti-racism means I really care what race you are. The anti-racism has as its premise that we are going to treat you in accordance with your race. We are going to treat you in accordance with whether or not you are a victim by your race or a perpetrator of oppression by your race. And therefore, we are going to hire you if you're the right color, and we are not going to allow you to apply if you're the wrong color. Whereas the classical liberals would say, apply, we'll pick the best person.
Yeah. How is it so upside down? Like the idea, like it used to be to not be racist, you shouldn't treat people differently based on the color of their skin. Now, right, to not be racist, you have to treat people differently based on the color of their skin. How did we get so upside down? Now we're back to culture, right? How did we get?
Well, we're back to culture.
How did we get so upside down?
We're also back to critical theory and social justice, right?
Yeah.
So here is one. Here's a competing premise. In the classical liberal view, one of the fundamental legal ideas is equality of treatment under the law. Or if you like, blind justice. Justice is supposed to be blind. What do we mean by that? We mean that the law should not care who you are in terms of your external characteristics. We don't care. We don't treat you differently whether you're black or white, rich or poor, male or female, straight or gay. We don't care. If you commit a crime, we just care about the crime. What did you do? Not who you are. What did you do? Okay. But that idea is eroding. The law is beginning to care who you are. The idea of blind justice is going out the window. Not entirely. It's a slow process, but you can point to situations in which that idea is being lost. So we have a section of the Charter, section 15.1, and that section in my books is written so as to guarantee equal application of the law, meaning the same rules and standards apply to everybody, regardless of your identity. And then we have section 15.2. Section 15.2 is written as an exception to 15.1, and 15.2 basically is the affirmative action exception. You know, if the government takes it upon itself to create a specific program so as to overcome historical differences, well, we're going to allow that to happen and not say that it violates 15.1, but it's just a narrow exception. Here's what's happened. Ever since the Charter was introduced, the Supreme Court of Canada, basically, over time, has said that that first part of 15, the one that says equal application of the law, in other words, blind justice, that section doesn't mean that. Instead, they have said even 15.1 is a section that requires substantive equality. In other words, equality of outcome between identity groups. And so the foundational idea of equal treatment under the law has been undermined over time by our own Supreme Court. And so let me give an example of the implications of this. A recent last 3 or 4 years, the Supreme Court of Canada heard a case about a job sharing program established by the RCMP. The RCMP established this program wherein full-time members, and everybody was full-time, they said, you know what, we can have part-time members. We're going to have a job sharing program wherein anybody who wants to work part-time instead of full-time can combine with another employee and together amount to a full-time employee, full-time job. And we're also going to include in this a pension program for these part-time employees, which is calculated the same way as the full-time pension. That is, you get a pension in accordance with the hours that you work through your career. The program was open to anybody. Any member of the RCMP could sign up for the program. Here's what happened. A greater proportion of women than men chose to sign up for the program. And therefore, at the end of their careers, they had lower pensions than the men because they'd worked fewer hours. And a group of them came forward and claimed that their equality rights under Section 15 had been violated. And the Supreme Court of Canada said, yes, they have. Because this program produces unequal outcomes between men and women. Notwithstanding, the program is open to anybody on equal terms, exactly equal terms. Supreme Court of Canada said that program is unconstitutional. That is now the meaning of Section 15.
Oof. What happened? What would happen if, because I assume it wasn't just women who picked up that program.
Correct.
Did any of the men who picked up that program try to litigate the same argument?
Not a hope. Not
Why?
a hope.
Why?
Because the way these sections have been interpreted, they've been interpreted to mean that they require equal outcomes in favor of historically disadvantaged groups. And let me tell you who those groups are. Essentially, everybody except straight white males.
Right. Right. And so we must flip the pyramid and put the straight white males on the bottom of it.
That's correct.
Yeah. Are you practicing law, or do you just teach right now?
I primarily teach. I do a little bit of consulting on the side, but I primarily teach. For about a decade, I sat on the Ontario Environmental Review Tribunal as an adjudicator and a mediator on the side. But yeah, I'm mainly an academic. Well, right now, I'm the executive director of this rights probe think tank, on leave from my teaching role at Queen's, but I'll be going back to it soon.
Okay. How much do you have your ear to the ground on the litigations surrounding COVID-19?
Oh, a lot.
Yeah? Can you tell me about that?
Yeah. Well, yeah, sure. There have been a lot of challenges to a lot of COVID rules that, for the most part, have been unsuccessful. I mean, the record against COVID restrictions is disappointing. There've been, as you know, there've been lockdowns and quarantines and masking and vaccine mandates, and a lot of challenges have been brought, and most of them have failed. And some of those decisions, I think, are disappointing and incorrect, but a lot of them are not incorrect because people, I think, believe that the Charter provides rights in substance that it doesn't actually always provide. But the courts on the whole, I think the pattern has been the courts have embraced the government's COVID narrative. You will see courts in various ways basically adopt the government's view on this. So, for example, in the quarantine challenge to the federal court, the court basically said, well, this is under Section 7, liberty, security of the person. If you're made to go into a quarantine hotel after arriving, okay, well, that might infringe your liberty, but it's in accordance with the principles of fundamental justice. So there's nothing to see here. Go away. In other kinds of cases, judges have taken judicial notice. Judicial notice.
What does that mean?
Okay, so judicial notice is a thing that courts are empowered to do. So back up a step. To establish a fact in a court proceeding, you need to provide evidence. A court hears evidence and decides the facts. And so the two parties will come forward and say, one will say, well, this happened this way. And the other party will say, no, it didn't. It happened that way. And they'll both bring witnesses, two different kinds of witnesses, lay witnesses who are on the scene and saw something or did something, and expert witnesses who will look at what the facts are and then come to opinions about what it means or how it works. So, for example, you might have a medical malpractice case, and some plaintiffs got in for surgery, been injured, and claimed that the injury is due to negligence in the way that the doctor performed the surgery, for example. And so you need to bring the lay witnesses in, you bring the plaintiff in and say, well, I was this person, I had this consultation, I said I wanted this surgery, I went on this day, and they did this, yada, yada, yada. And then you'll also have lay witnesses come in and say for both parties, well, the doctor did, if the doctor did this, then that did or did not cause the injury because, and here's all the medicine. Okay. And the job of the court is to hear all this evidence from the witnesses and decide, well, what actually happened? And they do this all the time. Judicial notice is a way for a court to find a fact without evidence. Now, they do this because there are some facts that are so notorious and obvious that it would be silly and a waste of time to require the parties to prove it. So the sky is blue is a fact that the court will take judicial notice of. A statute that has royal assent is a valid statute, unless there's evidence that it's not, or something went wrong in the process of putting the law into place. In the absence of that, though, the court takes judicial notice of the fact that the law is valid, and so on and so forth. The earth goes around the sun. But judicial notice, that is, finding facts without evidence, it's not intended to apply to the very facts that are in dispute in the case.
Right.
But that's what has happened on occasion in these COVID cases. The judges have said, I'm taking judicial notice of the risk of the virus, of the safety and efficacy of the vaccines. They've done this, for example, in family law cases where the matter in dispute is whether or not, divorced parents, one parent wants the child to be vaccinated, the other one does not. And the court comes along and says, I'm taking judicial notice of the fact that the virus is dangerous to the child and that the vaccine is safe for the child. Well, hold on. Those are the matters that are in dispute.
Mm.
So this is just one of the ways that the courts have avoided having to confront the science about COVID and the vaccines and so on. And they one thing they desperately seem to not want to do.
Yeah. And it's certainly not not settled on all of that science, is it?
Oh, no, not. No, it's not settled on. It's very contentious. And
it's still
that's
being
partly
it's still
why
being
they're yeah, go ahead.
it's still being developed. There's new information that comes out every day that changes information that was published, a year ago.
Sure. And it's a tangled web. And I understand their reticence to be the ones to pass judgment on what the science is at this particular moment, because after all, they're not scientists. But it is the job that they have. I mean, part of the reason that judges, and this is the concept, the theory, part of the reasons that judges are equipped to make decisions and come to findings on contentious facts, including scientific ones, is not because they have expertise. It's because they don't have expertise. So they, in theory, they don't have the assumptions and the predilections that a specialist would enter the courtroom already having. The judges, in theory, have a blank slate. And that's what you want. You want a blank slate decision maker who knows nothing about it. So the parties can start from scratch and say, Your Honor, this is how it works. But in this situation, the courts appear to have been very reluctant to step into that space.
Do you see that? Do you see the wind shifting at all, or are they hard nosed and straight lined about that position still to this day?
Well, every court and every judge is different, and so I'm not saying that it's not going to happen. And I think there's also a myth that courts are immune from public opinion. I don't think that's true. And so as time goes on and if the views about this whole thing shift, then maybe we will start to see different results. But so far, it's been pretty consistent that the challenges to these rules have been rebuffed.
So we're back to culture again. It's a culture thing. The culture has to influence the courts, and the courts aren't going to change until the public opinion changes.
Yeah, and it might not be quite so literal as, like I'm not talking about a poll. I'm talking about sort of the larger perception of what is viewed in society to be true and not true, valid and invalid. I'm talking about the ethos of the country, and I wouldn't be surprised if that made some difference.
Do you see that? Do you see that ethos changing? Do you have hope for the direction we're headed? I kind of take up the opinion that we went so far, so fast one direction. It took a little while to catch up, but more and more people are catching on and going, hey, wait a minute. That all was a little weird, and it keeps getting more weird because we keep finding new things out. Do you see the cultural shift happening? Are you hopeful for the future?
Well, I perhaps. So the one possible silver lining, or one of the silver linings, it might be a dark one, but one of the silver linings about COVID, it might be just that. It might be that it happened so hard and so fast, that it was such an overreach so suddenly that people may, at this stage, may be able to think, well, hold on, what just happened? And we'll be able to see the extent to which we overdid it. And in that way, we'll expose these other broader cultural forces we've been talking about. And maybe the overreach will maybe will help us regain or push back on the other dynamics that are taking us down a bad path. I don't know if that'll happen. I'm not sure that we're not already too far gone about that. But on the COVID matter, we at least see now some people suggesting that, oh well, and these are people who pushed the hard line, who pushed vaccine mandates, who pushed lockdowns, who pushed kids being out of school, saying, oh, you know what, maybe some mistakes were made. Let's just wipe the slate clean and start again.
Yeah, this amnesty thing that's come up over the past couple, this pandemic amnesty thing.
Right. Right.
What do you feel about that?
That's an indication that maybe the story is changing in the broader culture. Maybe more people are realizing that, this is not quite what we thought it was.
Yeah.
So that's a good thing.
Mm-hmm.
But this idea that we're just going to move on, I mean, come on. The excuse is, and this, we're referring in part to this recent Atlantic article. Yes,
yeah.
That argues just this. This is the Emily Oster, I think her name is, wrote a piece in the Atlantic, basically making this case that time to move on, folks. Let's just put it down and carry on. But the argument, in part, goes like this. The argument that she makes anyway, that those people who maybe pushed too hard, that was understandable because, we didn't know enough about it at the time. The information wasn't complete. It was uncertain, as you refer to. All the facts weren't obvious. And so, it was understandable that people would have pushed for what they pushed for. And if you got it right, you're probably just lucky because you've made certain assumptions about the facts and those turned out to be right. So it's not like you are morally superior or anything. You just happen to be lucky. Okay. Well, I reject that take for this reason. As far as I'm concerned, the rightness or wrongness of these measures was not primarily dependent upon the facts. If they'd been right about various things, and by the way, lots of us said this was wrong immediately. In March of 2020, when they announced the lockdowns, basically said, you shouldn't leave your house. Your business must be closed. Don't walk through the park. Don't take your kids to the playground. Some of us immediately said, bad idea, terrible idea. You cannot do this. So will we just be lucky because we figured out the facts? Even as you accepted the facts as they were being presented then, it was still wrong because what you were doing was making people's decisions for them. And those people who pushed hard because they thought the facts were a certain way pretended that their pushing was justified by the facts. That's the part that's wrong. And they were willing to coerce the rest of us into doing things we did not want to do because they were scared. That's the problem. And that problem does not depend upon the facts. So as far as I'm concerned, those people are culpable for doing what they did, regardless of how uncertain the facts were.
I have another angle at that argument. Section 1 of the charter basically says the government can nullify any section of the charter if it is demonstrably justifiable or justified, right? That's what that's what section 1 means. It says, here's the charter of rights, here are your rights. But if we can demonstrate a reason for violating those that is beneficial, then we can violate them, essentially. I mean, you might correct me, but that's how I interpret it.
That's essentially correct, yeah.
By admitting in their own admittance, we were in the dark, we didn't have all of the facts, then it wasn't justifiable. You could not demonstrate that it was justifiable what happened. Therefore, that would be the argument that I would make.
Well, I mean, perhaps, but I think they're going to characterize it this way. They're going to say, well, at a certain moment in time, especially early on, the facts looked to be this way. And if those facts had turned out to be correct, and we were dealing with a period of uncertainty, of course, and there was no way not to be uncertain. But if the facts had been that way, therefore we were justified. And after all, it was better to be safe than to be sorry. We were erring on the side of protecting people rather than on the side of letting them die. That's the way they would put it, I think.
Yeah.
It might be it.
I understand the counter argument.
Right.
But
and you know, other courts have used Section 1 to say, oh yeah, no, this was a reasonable thing for the government to do. There was one case, I forget which one it was now, basically said, you know, this trying to deal with this virus was like being at war. And during times of war, governments are entitled to expect sacrifices from their people. And so just wiped the whole thing away. Said, fine.
Well, I disagree.
Oh, I do too.
We got to wrap up here. Do you have any parting thoughts for anyone who feels like they want to take up a legal argument, or any advice that you would give to people, or resources that they might consume to understand where their litigation might stand, or anything like that? Where do people go to get information?
Sorry to interrupt. Carrie, I didn't let you finish. Go ahead.
Just where do people go to get information to understand their rights better?
Yes. There are all kinds of resources from people, groups, organizations that are working on this side of the argument. My own outfit is called Rights Probe. You can find us at rightsprobe.org. But there are all kinds of other outfits as well, writing things and doing interviews and investigating things. Very valuable stuff. I start to list them all, but there's a whole long list. Bright Light News is one place I would recommend. They do very, very good work interviewing people on this. There is just announced yesterday, Preston Manning announced an initiative called the National Citizens Inquiry. They're going to try and put together an inquiry like a royal commission, like an official government inquiry. It's not going to be that, because it's not being done by the government. This is a private thing in the sense that it's being put together by certain nonprofit organizations, but it's going to be like an inquiry, going to start in early 2023. And if you want to have a look at what they're trying to do, it's at nationalcitizensinquiry.ca. But if you just go onto Twitter or there's all kinds of things on Substack. There are all kinds of people. There are lawyers and doctors and professionals, but also non-professionals who are doing great work on this. There is a community, a movement even, if you like to put it that way, that is on this case to make the case that what has happened to us during COVID was wrong, illegitimate, unjustified, hopefully unlawful, but we haven't crossed that threshold very well yet. But that struggle is still going on. And there's lots of reasons to be hopeful, because there are so many people who are on this page together. And if I can put it this way, we talked earlier about the ways in which the country had been disappointing in demonstrating a set of characteristics which were not what you'd like to think the Canadian character was like. But there was a moment in Ottawa with the truckers where you saw again this has happened to me. I was in Ottawa when the truckers were there. I thought to myself, this is the country that I thought that I knew. This is the country of people who were modest, resourceful, patriotic, self-effacing, courageous, and peaceful. They were there because they were angry with what the government was doing to them, but they were also joyful to have found each other. And that sense of community exists still to this day, I think, amongst people who are trying to face this problem head on.
Amazing. Well, thank you, Mr. Pardy, for your time. I appreciate you being here, and I hope we get to chat again soon. This was a very informative and interesting conversation. So thanks again for your time.
Thank you, Zach. I enjoyed it. Cheers.
Thank you for listening to The Canadian Story. You can find us on Instagram and Twitter at The CAD Story. That's The CAD Story. If you enjoy this podcast, please share it with your friends and family. Let's work together to remind Canadians how great their country is.